What is law? This is one of the big questions raised by the idea of internet law. Most people probably think of law as something written down in a statute book or court opinion. That is, codified or encoded in an official writing. Many people might add that law is issued by a sovereign, such as a king, judge, or legislature. In the study of jurisprudence, we think of positive law as man-made law, in contrast to divine or natural law. And we start to assess the legitimacy of the rule of law in terms of whether the positive law is publicly accessible, consistent with broad principles of justice, and issued by a proper sovereign under principles that govern the sovereign as well as ordinary citizens. The reference to divine or natural law demonstrates that positive law is not the only possible kind of law. Whether there really is some kind of divine or natural law, obviously, is a hotly contested claim with a long history. But every sane person agrees that there are some forms of law besides positive law that govern human conduct. For example, if you jump from the roof of a tall building without a net or other special equipment, you will fall to the ground and hurt yourself. No sane person believes he or she is exempt from the law of gravity. And even if you believe this, you'll soon find that you are painfully mistaken. So, there are at least some laws of nature that constrain human conduct. Or at least we commonly refer to phenomena such as gravity as laws of nature, even if philosophers of science debate the concept. We also know from experience that we are subject to private agreements and social norms that shape and constrain our actions. Maybe you're listening to this lecture at home in your underwear. When we meet together as a class, you'll certainly be wearing more clothing. One reason why is that the law school has some basic conduct policies that would preclude showing up for class in only your underwear. These policies are part of an agreement between you and the law school, even if you otherwise could stroll around in your underwear without violating a public exposure statute. A form of private ordering constrains your conduct. Alternatively, let's say you have a side job of performing at parties as a clown, and that you're listening to this lecture at home while wearing your favorite clown costume. When we meet together as a class, you'll probably be dressed in the sort of neutral, casual clothing considered appropriate for law students. Why not wear your clown costume to school? There's no statute against wearing a clown costume to class, and it probably wouldn't violate any school policy. The main reason why is probably social convention. If you wear a clown costume to school, your colleagues and professors will think you're, well, a clown. You'll face some degree of ridicule and ostracism, even though there's no inherent difference between clown pants and a pair of jeans when it comes to covering what's underneath. There's a social norm that constrains your conduct. In addition to positive law, then, we've identified at least 3 other sources of constraints that could be considered forms of law: laws of nature, private ordering, and social norms. All 3 of these additional sources come into play in connection with internet governance. At one level, the notion that the laws of nature constrain human conduct in relation to the internet seems obvious. How could they not apply? But recall our reference in a prior video to the influence of science fiction literature on our concept of cyberspace. We imagine cyberspace as a place that frees us from the ordinary physical constraints of time and motion. In the real world, I may be an aging law professor from New Jersey, but in some virtual world, I may be a demigod who controls vast armies of orcs. Alas, however, ultimately cyberspace also is subject to the laws of physics and mathematics. That is, at least, the communications network that makes it possible for me to assume the character of a demigod in an online game remains a physical thing, and the information that is communicated in relation to the game is subject to the laws of conservation of information. At the physical level, cyberspace does not change the properties of the light and electricity that carry the game information, or the properties of the fiber optic cables and wireless radio frequencies that permit a carriage of certain bandwidths of light and energy. At the content level, the game's semantic content cannot be infinitely compressed without losing meaning. Consider this sentence: I am Professor David Opterbeck. Including punctuation, it contains 31 characters that communicate a substantial amount of information about me. We could think of various strategies for compressing the number of characters used to communicate the same information. If we had a rule that said P means professor, and capital letters are personal identifiers, we might compress this to IPDO. If carriage bandwidth is limited, this sort of compression allows larger amounts of information to be communicated more quickly than would otherwise be the case. But compression can entail a loss of data. Using 16-bit encoding, the original data string I am Professor David Opterbeck is comprised of 30 characters. 30 characters times 16 bits per character equals 480 bits. Compressed to 4 characters, IPDO equals 64 bits. It requires less bandwidth to transmit 64 bits of data than 480 bits. But 480 bits minus 64 bits equals 416 bits of potentially lost data. The question is whether the original message can be reconstructed effectively by the receiver. If the only possible personal identifier connected with DO is David Opterbeck, this might work without a loss of data at the receiving end. But if DO could signal other potential identifiers, say David Ortiz or Doctor of Osteopathy, the receiver might not accurately reconstruct the identifier, and most of those 416 bits of data compressed out of the original message might be lost. These concepts are important for our discussion of Internet governance because the network processes limited bandwidth and therefore requires algorithms, protocols, or code for data compression. These protocols or code elements must be common across the entire network, or else the compressed data will come out the other end as gibberish. In addition to algorithms for compression, the Internet requires protocols for translation across different devices. Let's say I want to tell my friend Hernando, who speaks only Spanish, that I'm hungry. If I say I am hungry, Hernando might not understand me. He needs to hear tengo hambre. We can make this work using a translator. Similarly, I may want to send the message tengo hambre to Hernando electronically. I may want to use a Microsoft email client on my IBM laptop, which is connected to my home wireless network, and Hernando may want to receive messages from me using the email client on his Apple iPhone, which is connected to a cellular phone network in Ecuador. In the old days of computing, this sort of cross-platform communication might have been difficult, if not impossible. But it's easy on the Internet because the network employs common interconnection protocols. In fact, arguably, these common interconnection protocols define the Internet. To connect a device to the network using these protocols is to be on the Internet. An early generation of scholars, activists, and theorists could be considered cyber exceptionalists. They thought cyberspace was and should be forever ungoverned by traditional sources of law and governance. This perspective is reflected perhaps most famously in John Perry Barlow's Declaration of Independence for Cyberspace. Barlow proclaimed,
"Governments of the industrial world, you weary giants of flesh and steel, I come from cyberspace, the new home of mind. On behalf of the future, I ask you of the past to leave us alone. You are not welcome among us. You have no sovereignty where we gather."
But the role of compression and internet connection protocols in cyberspace quickly led another generation of cyber law scholars to argue that, in cyberspace, code is law. Cyber law scholar Lawrence Lessig suggested we should expect a future of control in large part exercised by technologies of commerce backed by the rule of law, or at least what's left of the rule of law. Lessig argued that
in real space, we recognize how laws regulate through constitutions, statutes, and other legal codes. In cyberspace, we must understand how a different code regulates, how the software and hardware that is, the code of cyberspace that makes cyberspace what it is also regulates cyberspace as it is. As William Mitchell puts it, This code is cyberspace's law. Lex Informatica, as Joel Riedenberg first put it, or better, code is law.
Yet another generation of cyber law scholars questioned the premise that the control over code was a form of law unique to cyberspace. As Jack Goldsmith and Tim Wu stated in their book Who Controls the Internet? Illusions of a Borderless World, when government practices control through code, it is practicing a commonplace form of intermediary control. What could be considered a third generation of cyber law scholars responded by suggesting that Internet governance should be a global issue, with some degree of coordination by an international body. Some of this third-generation thinking is evident in the World Summit on the Information Society principles in your readings this week. Of course, you shouldn't think that later generations of cyber law scholarship have replaced earlier thinking. While there are few cyber utopians today, there's a broad range of thought about whether and to what extent cyberspace is a unique space, whether and to what extent national governments can or should control Internet infrastructure, and whether and to what extent international organizations should coordinate Internet governance. Internet law has responded to these tensions in various ways. Acting under the deregulatory impetus of Section 706 of the 1996 Telecommunications Act, the FCC's decision in 2002 to classify broadband Internet as an information service ensured a light regulatory touch rather than the heavy one imposed on other telecommunications services. Although the Internet never became the libertarian utopia imagined by Barlow, this light-touch regulation allowed technologists and community members to manage broadband Internet's growth rather than bureaucrats. But progressives changed their mind when the Internet backbone market became highly concentrated. Leaving cyberspace to the people turned out to mean leaving cyberspace's physical backbone to a few large corporations. It became obvious that cyberspace was not a borderless world after all. As a result, progressives advocated for network neutrality rules in the FCC's 2015 Open Internet Order. These rules, however, were quickly reversed after the FCC's composition changed during the Trump administration. As another example, Section 230 of the Communications Decency Act, which was part of the Telecommunications Act of 1996, exempted Internet hosting sites from publisher liability. This exemption garnered the praise of many open Internet activists, even though they still disapproved of other aspects of the CDA. And it supported countless instances of learning and creativity. But it also helped produce today's toxic social media culture. Nobody in 1996 anticipated the growth of social media platforms owned by a small number of companies as we know them today. As these examples suggest, the Internet is both exceptional and ordinary. Today, enormous problems relating to cybercrime, surveillance, intellectual property, equal access, harassment, and privacy continue to bedevil cyberspace. Alongside the public Internet, there exists a dark web through which international criminal organizations sell stolen data and offer cybercrime as a service, or CAS, which includes exploit as a service, or ES, ransomware as a service, RAS, and hacking as a service, HAS, through sophisticated cloud-based delivery markets. And now, as we enter the AI age, a development also not really accounted for in the early years of Internet governance, the same problems are affecting another layered social technological resource, the AI technology stack. In this course, a big question we'll consider is how the technologist-driven open-source collaborative model of the early Internet relates to this enormous governance problem of security at the economic, personal, national, and international levels. Proponents of the open collaborative model argue that it produces a more stable and secure end product because the work of checking for bugs and holes is broadly distributed. But others note that it's naive to assume that the voluntary social norms that unite an open source community will supersede the interests and power of organized criminal groups or of national or other non-nation state actors who desire to exploit the network. While nation states treat cyberspace, and also AI, as domains of national policy and warfare. Throughout the semester, then, keep in mind how the question of security concerning Internet and AI, technologies that have already dramatically altered and will continue to dramatically alter the course of human history, implies big questions about the nature and purposes of law itself.